as you heard, I grew up in a law enforcement family. You know, always thought I wore the white hat, truth, justice, the American way. And I didn't like the fact that I might be doing something illegal. And the more I looked at it, the more I kind of asked around and thought about it. Shortly before I decided to leave, someone said that they were going to shut down the program. Something from the program got into one of the regular application warrants. The sitting attorney general may be indicted for the first time, and the judge that reviews these things is just really upset. And then there was one other characteristic, is that my boss, who I really admire, a fellow named James Baker, not the former Secretary of State, would tell us that if we were afraid of putting our name on a warrant on the application, that he would put his name on it. And so I would look at these documents and said, what is he talking about? Why should I be afraid of putting my name on this document? So I put all of those things together. I thought that we were doing something illegal, and I came to the Hill and spoke to an AUSA that I knew, told that AUSA if she could go to the Senate Intelligence Committee or staff, and if the Congress knows what we're doing, then I will just back away. She was never able to tell me that. She came back and said, you know, whistleblowers don't fare very well after they do their act, and you want to be really careful. And so I ended up going to a reporter with the New York Times. And what was interesting was I was the only person from the Department of Justice that they knew of that had kind of had these reservations. Of course, now we know that there was a confrontation in John Ashcroft's hospital room, basically right at the time that I was having these same concerns. And the New York Times had sources from the NSA, and the NSA was very concerned. These people were concerned that we were violating the Fourth Amendment and violating the Constitution of the United States. And I basically, as I understand it, supplied the missing link as to how these cases were handled separately through the Department of Justice. I actually talked to the New York Times a little before the election in 2004, wasn't sure when the story would run. It didn't run for another 14 months, and I kind of just, I don't know, I had this, that black cloud of Newsweek hanging over my head, I suppose, metaphorically. And it was finally published, as Jesselyn noted, in, I believe it was in December of 2005. And Mr. Bush, President Bush, said it was a despicable and shameful act. And then the very next day, he confirmed the fact. He spoke about classified documents, which I had not done. He confirmed the fact that we were wiretapping Americans and American citizens without warrants. So that's my story. My lawyer was very concerned because in August of 2007, 18 agents came rushing through my house and took our computers and our cell phones and our Christmas cards list. And they were all armed. And I'm still under investigation, apparently. We have been told that it will be decided by the Obama administration what to do, but my lawyer didn't want me to reveal too much or say anything stupid here. So I'll try not to say anything stupid. Thank you.
Well, hi. As Jesselyn said, my name is Mark Rotenberg. I'm with the Electronic Privacy Information Center here in Washington, and wiretapping has actually been an interest of mine going back 25 years because in the early 1980s I worked with a group of organizations, including the ACLU and technical experts and Senator Leahy, to update the federal wiretap laws because we were entering a world of new technologies, of email, of stored communications, and there was clearly a need to ensure that the Fourth Amendment protections that had previously been established by the '68 Federal Wiretap Act carried forward for these new forms of technology. And I've spent actually the last 25 years working in a variety of issues related to wiretapping, and I've returned to Senator Leahy's staff on the Judiciary Committee, also learned about open government laws. And so post 9/11, when there were a lot of government surveillance activities that caused concern in the civil liberties community, my organization, EPIC, began a series of Freedom of Information Act requests to try to determine exactly what was the scope of domestic surveillance, the surveillance taking place on American citizens here in the United States, by our own government. We uncovered, for example, the fact that the Department of Defense had gone to the U.S. Airlines and asked that the passenger records of U.S. travelers be turned over to the federal government for analysis without any particularized suspicion or reason to believe that any passenger had actually engaged in a criminal activity. We also uncovered a story about a program that a former national security advisor, John Poindexter, was pursuing called Total Information Awareness. And you may remember that as well, which was an effort to obtain information, all information that could be obtained about American citizens. But I think the most interesting post 9/11 FOIA request that we pursued began actually in mid-December of 2005. That was the day that the New York Times story appeared regarding the president's warrantless wiretapping here in the United States. And I have to say, for someone who had spent a very long period of time debating provisions of the Patriot Act, expressing concerns about the very broad scope of the FISA, because we knew, by the way, in 2005 that the number of FISA warrants had actually exceeded the number of Title III warrants, the traditional wiretap warrant, the one with all the safeguards built in. I think by 2003 there were more FISA warrants being issued in the U.S. than there were Title III warrants. But we always assumed, and this is the key point you need to understand, we always assumed that there was a debate taking place within the context of the federal legislation that authorized wiretapping within the United States. In fact, FISA said explicitly that it and Title III were the exclusive means of electronic surveillance in the United States. FISA even anticipated that in the extraordinary circumstances of war, the president would be granted a 15-day window to pursue whatever measures he felt appropriate, with the understanding that he would come back to Congress for whatever statutory authority he now thought appropriate. So this was always a debate up till December 2005, except for a few people who knew before that date that we thought operated within a legal framework. And when we read the New York Times story, we understood the significance. We understood that the President Bush, had made a decision that he was no longer bound by the acts of Congress. And within 2 hours, I think, of when the story appeared that morning, we had a Freedom of Information Act request to the Department of Justice, and it was very focused. We didn't ask for techniques and methods. We didn't ask who they were investigating. We didn't even ask for records about American citizens who may have been unlawfully surveilled. Although in retrospect, I think we would have been perfectly within our rights to pursue some of those requests. We asked only for the legal opinions that supported the president's position that he had the right to conduct this type of surveillance within the United States. We asked only for the memoranda produced by the Office of Legal Counsel that would have made it possible to engage in this type of surveillance. And we have spent almost, well, now more than 3 years trying to obtain nothing more than the justification for the government's conduct. Now, the extraordinary story, and it's really just within the past week that I can share this with you, is that the new Attorney General Holder, last week began to release some of the OLC memos that were produced by the Office of Legal Counsel and John Yoo and others in those days post 9/11. Some of the material has been released in whole. In other areas, we see only a summary. The most significant memo, in my opinion, which if you haven't seen, you should take a look at, is the one that Stephen Bradbury authored this year on January 15th. It was the outgoing memo, Instructions to the Department of Justice, regarding the legal force of certain memos that had been previously issued by the department.